The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Two cases will be submitted this afternoon. Those cases are Iowa Supreme Court Attorney Disciplinary Board versus Theodore Sporer, and the second case is Brenda Appellant versus Brian Jones. That last case is now submitted to the court without an oral argument, and we will hear the arguments in the attorney disciplinary case. Mr. Sporer.
If it please the court, my name is Theodore Sporer. I'm the respondent in this case. I simply cannot understand how a simple ratification and estoppel defense became this. The facts I don't think are particularly disputed for the most part. There was a hearing predicated on a series of settlement offers. The first settlement offer in this post-divorce hearing, or in this post-divorce matter, was submitted by me or sent by me to the opposing counsel, Mr. Tim Duffy. That document is not disputed as to its existence or its receipt. Mr. Duffy responded with a counteroffer. The scope of the counteroffer was significantly different. The original offer proposed a complete release of all claims, including all claims arising out of the judgment. The counteroffer purportedly accepted the original offer, except for excluding all of the quadro claims in the initial document. The existence of that counteroffer and its recognition as a counteroffer and a rejection of our initial offer isn't disputed. From those facts, settlement negotiations took place. The other undisputed facts are Mr. Duffy's assistant picked up a settlement check for $27,000 in our office. She was asked to memorialize the terms of the agreement that with which I believed we had reached and or were offering. Because even if there was no agreement, there was certainly a statement signed by Mr. Duffy's office, and how that became an agreement I'll discuss in a minute. Moreover, the settlement check was accompanied by two other documents, both of which were indisputably created after the purportedly false handwritten note. Each of those two documents was identical to the original settlement offer, as in they contained identical terms of the scope of this release as a general release of all claims. If one assumes for the sake of argument that the handwritten note was never created, there is still never a single document that left my office that in any way expressed any terms other than a complete release. So the first question I suppose to turn to would be the concept of why this handwritten note was purportedly fabricated. It seems to be the theory that that note was fabricated to establish evidence that Mr. Duffy's counteroffer was rejected. There would be no reason to do that, to fabricate that document, because the two documents that followed it are expressly rejecting the scope of the counteroffer and the limited release, and they are specifically describing a full and complete release of all claims. Those documents are the short form settlement agreement that was signed by Mr. Duffy's secretary, and then subsequently ratified by Mr. Duffy and his client, and the long-form settlement agreement that is as explicit as I know how to make a release and a settlement agreement. So the initial theory, and the theory advanced by the board in their brief, is that this document was created to establish evidence of the rejection of a settlement offer, which would make sense had I remained silent after receiving the counteroffer. But if, in addition to the handwritten note that was sent back, there was also the two subsequent documents. Now, when I argued this case before Judge Staskell, and God knows I should have briefed it, but the estoppel and ratification arguments were fairly direct. Mr. Duffy.
Let me just interrupt you. I'm going to take it in little small bites if I could.
Thank you, sir.
Trying to go through the whole scenario here, but I guess number one, I really have a question that there was ever any agreement, period, or any relinquishment of a claim by the opposing client. And do you think there was an agreement? I mean, what documentation is there in the record that shows there's any type of agreement here that she's going to give up any type of quadro rights that she had in these retirements?
Well, that goes to two parts. The first part is, at the time that, well, the first part is a simple agreement by ratification.
Okay, so then you're saying there was an agreement, and then by Mr. Duffy sending his secretary legal assistant over there to simply pick up a check, that's the ratification of this agreement?
No, that's the first act in a chain of ratifications. And by that I mean, had Mr. Duffy merely, had the secretary done nothing but sign that agreement, and then Mr. Duffy would have notified, not accepted the consideration and signed the check, and not seen the long-form settlement agreement, there would have been no agreement. I would not have then been able to say there was an agreement between the parties, because clearly there would have been nothing done that would indicate an acceptance of the terms in all of my communications.
But then her acceptance is a ratification of that agreement then? Is that what you're saying? Her signing of that document or whatever?
No, the fact that the short form settlement agreement becomes a contract through two angles. The first of which is that there was no repudiation of it. I mean, there was no communication that said, this isn't our agreement for Mr. Duffy. And second, they accepted the consideration of the agreement. And those are the two elements that are sufficient to ratify the first signature, which I've never said standing alone in and of itself was the settlement agreement. Our settlement agreement began with the short form agreement, and then was carried through by keeping the money and by not repudiating what the secretary had done. So then the contract goes back to the date on which the act ratified occurred, rather than the date or time frame in which the ratification occurred. So that's one way it becomes a contract. So the larger question is, was there a meeting of the minds? I think there was.
Let me ask you about the long-form contract, paragraph 3. I understand the short form is the letter dated, I think, October 9th, and then the long form was 6 pages, if you will, of single-space typing. So we're all kind of on the same wavelength. Paragraph 3 of the long form says, contingent upon the execution of this settlement and release, defined term, by the parties hereto, and payment by Gary, Linda agrees to accept, and it goes on. But the settlement agreement and release was never executed by both parties, I don't think.
Well, therein lies the estoppel theory. Those facts are pretty simple. First of all, if I could digress for just a moment as a predicate to answering your question, the Mr. Duffy has never denied and testified repeatedly in more than a dozen places that he knew that he did not agree with the scope of the long-form settlement agreement, that he knew that I was requesting a release far greater than he was offering.
Wasn't your agreement contingent upon execution of the settlement agreement and release? I'm just reading from paragraph 3.
I think that is indeed one approach that could have been taken. For example, Mr. Duffy could have done a couple of things. One, he could have communicated with me, we don't agree to this long-form settlement agreement. I mean, that would be the obvious thing that I think any lawyer would do if confronted by a document that contained a settlement term with which you disagreed, before you cashed the check. And had the alteration of the long-form settlement agreement not occurred, my time is 1 second away. Can I finish?
You can finish your answer and sum up.
Thank you. Had the long-form settlement agreement never been signed, Mr. Duffy could have taken the approach that we reject this agreement, but in taking that approach, he also has to reject the consideration from the agreement. They retained the consideration and then sat silently for, by his own admission, 8 days plus mailing time before ever giving any indication that he rejected the long-form agreement. Had that been the situation, I would have simply said, well, the short form, if you've accepted the consideration, the short-form agreement is ultimately the actual written terms of my offer and their acceptance. Obviously, long and more or less boilerplate settlement agreement that I'm sure we've all seen 1,000 times. With that, I would just simply say that I think these facts overwhelmingly show I did nothing out of the ordinary, albeit somewhat stubbornly and perhaps without a great deal of organization. But the idea that I fabricated this document, much less that I argued my estoppel argument without believing it's true, is just not supported by the facts of the case, the prevailing law on the substantive issues. Thank you.
Mr. Sporer, thank you as well. Ms. Quinlan.
Quinlan, sometimes these disciplinary cases, the underlying law has some relevance, and I think it does in this case. Would you agree, as a legal matter, that Mr. Duffy couldn't just have his client cash the $27,000 check and then mark up the settlement and send it back and argue, well, I'm not bound, I took the money, but I'm not bound by the settlement? That does seem like that's not the way you do things. If I have a dispute with a company and I send them a check, or especially if I send a lawyer a check with an agreement, and they have a problem, then they should send both the check and the agreement back, it seems to me. Isn't that right?
Well, I think when you approach this from the premise that we have two people who don't trust each other, that's part of this. That's underlying all of this. And the documents that had been exchanged up into that point in time were the letter that, the September 21st letter from Mr. Sporer that spelled out everything and included the middle paragraph that says the parties exchange releases of all claims either may have against the other, their counsel, and other privities. That was kind of stuck in the middle of it. And then in answer to that was Mr. Duffy's letter to Mr. Sporer, September 24th, where he said, sure, we agree, except for the following. And he talked about the quitclaim deed, which Mr. Sporer has tried to separate that, like we were negotiating everything, and the quitclaim deed wasn't a part of that.
Answer my question specifically. I mean, would you agree that it's not right? It's not really appropriate to take the consideration that comes with the settlement agreement, have your client cash the consideration, and then say, I don't agree to that settlement agreement, and send it back.
But Mr. Duffy's letter is the last document that Mr. Sporer, that either party had. and that's dated September 24th. Mr. Sporer said he received it on the 27th of September. Then there's
But I
no,
think what Justice Mansfield's saying, even if Mr. Sporer changed the agreement, say they had an understanding, and based on the last letter, whatever else you want to talk about, even though they had an agreement, when Mr. Duffy got the long form and saw that it didn't match his agreement, what effect, and I guess I want the same answer, what effect does cashing that check have on either an accord or satisfaction or a promissory estoppel argument?
I think if we were dealing with two people that trusted each other, I think that Mr. Duffy would have picked up the phone and said, hey, you know, you sent me something that doesn't match. I mean, was he required to do that by law? I guess the way I see all of the contract arguments on behalf of Mr. Sporer is that it's just a big distraction to get away from the issue of whether he made up this document.
There's two separate issues, and I think right now we're working on the second charge, and that is that he asserted that the secretary had authority and that was a binding contract, and so that's separate from the handwritten document. And Mr. Sporer is suggesting, well, it wasn't quite. It wasn't solely the secretary's signature on it. May well have not had authority to sign, and frankly, almost certainly didn't, I suspect. But by cashing the check, does that not change the legal posture of the parties at least? And is there a good faith basis to say, well, by cashing a check under the circumstances, they're now either estopped or have accord and satisfaction? You know, I think what he's saying, and I'm putting words in his mouth, I don't mean to, but reading the briefs and so forth, he's saying, well, you can't look at the secretary's signature in isolation. If that were solely the issue, does the secretary have authority to sign settlement agreements? And we didn't look at anything else, we didn't look at the record, that was the sole proposition before us, we'd probably say, well, no, but he's got more facts behind it. And so what about that second charge that, you know, the board said that Mr. Sporer violated, namely that he took a frivolous position or a position not supported by law? If we take it from a larger perspective, is there some support for it?
Well, I think there's support for it. I mean, we know that there's law of contracts, but what I was saying, I think he was misusing it in this case as a distraction to get away from the issue of what he did, his wrongful conduct. Are we looking at Mr. Duffy's conduct in terms of he should have done this or that and that he doesn't have a good argument for that? I think you can say that. Maybe Mr. Duffy should have called him or put something in writing and not change the document. But I don't think that it changes the fact concerning Mr. Sporer's conduct in this matter, which was to make up this document after the fact and to say that the secretary's signature was somehow binding, that this was in fact, he originally testified that he really didn't even need the long form contract.
He did, and there's some statements in the record that are perhaps exaggerations. I mean, he does state that, well, of course, it's unfathomable to me that the secretary didn't have authority. Well, it's fathomable to me the secretary didn't have authority, but
we also don't know when the secretary, whether she walked out with that document. That's another thing that is not clear from the record. She basically went over there to get the check. That was her understanding. She was picking up. When she turned around to leave with the check, the receptionist said to her, look, you need to sign this. And so what she said she did, and this is what she testified to, was that she signed what she thought was a document that she was just taking receipt of the check. So
sure, I get all that, but
Okay.
in the contempt in the second contempt proceeding at least, I think the resistance included accord and satisfaction, which arises out of, I think, cashing the check under circumstances that I think Mr. Sporer's argument is that it extinguished the obligation. So although he had statements saying it was unfathomable that the secretary did not have authority, do we view it in a larger context of what his actual defense was?
So I guess I don't understand what that takes away from the board's case.
Because there's two counts. One count says he took a position he took the position that the secretary had authority and that had no support in law or fact. And narrowly construed, that might be right, but the broader position that he took was really accord and satisfaction, and that the secretary's signature was just kind of part of it. That's a different kettle of fish, I think, and I'm probing whether the second count of the board's charge can be sustained. It's completely separate from the other issue
Right.
of the red ink on the document.
Well,
I'll
I-
return to that.
Okay.
There's testimony, I mean, Mr. Sporer testified that he sent the document, and that he wrote it contemporaneous, roughly on the 27th, I guess, of September. Mr. Duffy says he didn't get it. There's dispute over whether it was served or not served, so forth. Give us the high water mark of your claim that this was a manufactured document that really wasn't sent to any of the parties.
Well, I think when you go back, even in the summer of 2012, after the decree, there was some negotiation between Mr. Sporer and Mr. Duffy about how Mr. Sporer's client was going to pay for the marital home, his client's assets in the marital home. And during those negotiations, there was never, it was only about settling the marital property. And there was some back and forth going on about, well, Mr. Duffy was fine with these particular retirement funds that were not going to be cash. They were going to have value later on. But I tried to make a point that, and I think it's important that during those negotiations, Quadro was never mentioned. None of that was ever mentioned. And then we go on into that deal didn't work out. Mr. Duffy wanted to make sure that if that deal was going to go forward, that there would be no appeal. Well, that didn't work out. So then we get into the fall where Mr. Duffy files the contempt. And again, it doesn't make any sense that, I mean, I think Judge Staskell said it very pointedly, that it didn't make any sense that why would somebody just take a piece of paper and write on it in the context that it happened supposedly on September 27th, and then have it sent out 3 different ways. Mr. Sporer testified on June 5th that he wrote the note really fast, and during the grievance commission hearing, he went into this elaborate explanation of how he was very angry when he wrote the note, and all of these things happened. People were in and out of his office, and none of that was verified. In fact, his partner testified, her recollection was that at the point in time when he blew up and was so angry, it was because the check had already gone out, and he was upset that the check had been cashed. So there was also each time that Mr. Duffy sent a letter to Mr. Sporer about wanting the Quadro information, none of those were responded to. And then there was a mediation when Mr. Duffy filed again for contempt. Mediation was ordered, and the long form document never came up during that hearing, or that mediation, and neither did the handwritten note. The handwritten note didn't come up until the trial before Judge Stayskull. And it was actually marked as an exhibit that was, the date supposedly was October 23rd. So all of those things combined, I think, make it very unlikely that there just wasn't enough evidence to show that he would have written the note the way, under the circumstances that he said both times. They were inconsistent stories about the note. My time is up, I think.
It is. You may sum up, though.
I'm sorry. In summation, I think that even if the court doesn't find that, or finds that the one rule was not violated, that would be Rule 3.1. That the other rules that were violated still stand, and in fact, 2 of the rules were previously violated by the respondent in a public reprimand previously. And I would also ask the court to look at the aggravating circumstances in this case, which there are numerous ones. Thank you.
Ms. Quinlan, thank you as well. Rebuttal, Mr. Sporer?
Please the court. The board has no real answers about why my testimony was supposedly objectively believed by me to be false. At the time I testified, I had the benefit of all of the knowledge of the case to that point, hence perhaps aggressively when I said I couldn't fathom that she didn't have authority. I didn't really mean that every secretary wouldn't have authority, but
How many secretaries have authority to sign settlement agreements? I mean, seriously.
None do, Your Honor. None, and when I was saying that, I was saying it perhaps inartfully, but entirely in the context of it was unfathomable to me at that point, because the case, as Your Honor, as you noted, there were lots of other things that went along with not with her signature on the contract. The second issue I guess I wanted to discuss is if you have 2 lawyers that don't trust each other, I think that screams from this transcript. Wouldn't the party that received the settlement agreement be especially careful in reading it? I can assure the court I read everything Mr. Duffy sends me very carefully. If he didn't trust me, well, then he should have sent the agreement back along with the check, or held them and communicated with me and let me know, I don't agree with this long-form agreement. We could then have fought it out on whether the short-form agreement was binding, which in that case it probably wouldn't have been because it would have been timely repudiated and there would have been no acceptance of consideration.
Well, Ms. Flanagan, and I'm sorry if I have her name wrong, but she testified and really linked the red Sharpie writing to October 23rd, and your testimony was it went out on the 27th or thereabouts. That seems to be inconsistent, and then you did identify it as an exhibit ultimately as a note on October 23rd.
To be quite honest, I was looking at the different date when I typed that. I was very surprised to see that. But it also brings up, if there was any...
It's consistent with her testimony, I think, too, that it was October 23rd. In which case, one could understand the exclamation point. It's a little hard to see why there would have been an explanation, kind of exclamation point, on September 27th when you simply had a letter exchange.
Well, I'd also had an extremely unpleasant telephone conversation with Mr. Duffy shortly before I sent the letter. And second, I wanted to be clear. I don't know, I couldn't think of a way that I could have been more explicit about the nature of the release. I put it in every document that left my office. I spelled out a general release, which clearly is inconsistent with the terms of Mr. Duffy's counteroffer. And moreover, people lie and make up documents to gain something. I mean, I've read some cases where, like, lawyers have made up documents to get to enable them to make a motion to compel. The argument that I made begins with the signature on the settlement, or the short form settlement agreement. That's the argument that I was making. The prior negotiations aren't important to that, because the documents that follow that handwritten note are explicit.
Well, it might be, and it might be under the following scenario, I guess, and that it would be that when Duffy cashed the check, he thought by sending the check over under the circumstances, it was just following through on his September 24th, what you call counteroffer. And his view of it, at least, if I understand the record correctly, and I do urge you to correct me if I miss it, because it's somewhat lengthy record, but so he sends over his counteroffer on September 24th, and then he gets a call saying the check is ready, and he thinks, well, okay, my counteroffer's been accepted. Of course we weren't talking about the Quadro. Here comes the money. He's a little sloppy. They cash a check. Then he looks at the long form and identifies a problem and does the scribbling and so forth. So the note would kind of help you in that scenario by saying Duffy couldn't have thought that we accepted his the counteroffer the 24th because there was intervening communication.
If those were Mr. Duffy's claims, that would probably, I can see the court's point if that were Mr. Duffy's claims, but Mr. Duffy said he immediately knew that we had a difference in our belief as to the scope of the agreement, and that he knew that at the moment that they saw the agreement, and with that knowledge, he cashed the check. If I might sum up here briefly.
You may.
When you look through the briefs in the record, there are a myriad of witnesses that testify about the existence of an argumentative conversation with Mr. Duffy that were in my office watching me either write something out in red or remembering me writing something out in a bright red Sharpie saying this will get his attention. The board and the commission don't even mention Gary Propstein had a copy of this before when he brought the settlement check in. Ms. Gelbowitz testified as to how she delivered it. I mean, I didn't personally deliver it, I guess.
You had two people deliver it. Your assistant said she delivered it, and your friend said she delivered it.
Well,
Did I mischaracterize your friend, your associate?
friend, I guess, would be a fair association. I mean,
Well, we have two people testifying they delivered it.
well, the Ms. Gelbowitz, I literally did not know that she did that, although I'm not surprised when she did tell me that, because she was a smoker, and whenever something could be delivered in the immediate vicinity of our office, she typically took off to hand deliver it and smoke on the trip. If she hand delivered it, she took that upon herself. My instructions to her were to get this to Mr. Duffy, or to Duffy, actually. And so I didn't know anything about the second delivery. I do believe she mailed it. I'm reasonably certain she faxed it, although she was not good at keeping records. And I mean, I just can't believe she would tell me she did something by ultimately 3 different ways and didn't really do any of them. I mean, that's just not believable to me. And I think the fact that Mr. Duffy never denied seeing this until he was directed with a very pointed, leading, suggestive question by Judge Stayskool that gave him the chance to deny ever having seen this document, that at the end of the day, to summarize my last sentence, at the end of the day, that document means nothing. I couldn't use it to claim estoppel or ratification. That's the same reason that the original settlement offer meant nothing. Thank you.
Thank you as well, Mr. Sporer. The case of Iowa Supreme Court Attorney Disciplinary Board versus Theodore Sporer is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.